Well, welcome ladies and gentlemen to wonderful Western Australia and perfect Perth, and we've put the weather on for you. And welcome to God's own earth when it comes to the federation and the separation of powers between the Commonwealth and the states. We are the last outpost, as it were, the starship that is teetering on the edge of the virtual horizon before plummeting into the black hole that is sucking in all of the discretions and powers and appropriate authorities of the states. And your energy here will keep us on the edge of that virtual horizon and on the right side of it. Thank you to Eddie for the opportunity to open this session, and thank you to him and all of his supporters and staff for the work that they have done to put this conference together. It is no mean feat to do so, and I'm encouraged by the fact that this Society's attendance today is greater than the one last time, and indeed a record breaker for the Society for quite some time, if not ever. I think it shows that there is still energy amongst those that choose to turn their minds to this subject and really care about it, to ensure that the Constitution of Australia is operating properly, and to contribute their thoughts, their intellectual power towards structuring ways in which the Federation should work and was meant to work, not as some would like it to work for their advantage. I'm also encouraged by the list of people that are going to be speaking to you over the next day and a half. And I'm pleased to be able to introduce the first two of those, and I'll deal with them in order. And the first is the Honourable Justice Robert Mackenzie Mitchell of the Supreme Court of Western Australia. He was appointed a Judge of the Supreme Court of Western Australia in October 2014, one of my better recommendations and decisions, I think, and as a Judge of the Court of Appeal in July 2016. He obtained a Bachelor of Jurisprudence in 1989 and a Bachelor of Laws in 1991 from the University of Western Australia, and completed a Master of Laws with distinction at the University of Western Australia in 1997. In 1989, Justice Mitchell commenced work as a professional assistant to the Solicitor General of the day. He then completed his articles of clerkship with the Crown Solicitor and was appointed an Assistant Crown Counsel in 1997, Senior Assistant Crown Counsel in 2000, and Deputy State Solicitor in 2008. He was appointed Senior Counsel in 2007 and was Acting Solicitor General from July 2011 through to February 2012. He was a member of the Law Reform Commission from 2007 until 2011, and a member of the Legal Practice Board and a member of the Legal Profession Complaints Committee. In his capacity as Acting Solicitor General and in the State Solicitor's Office, he on many occasions gave advice to the Government of Western Australia on issues of a constitutional nature and on the appropriate balance between Commonwealth and state powers in particular cases. And so I'm delighted to welcome him here today to speak to us and to give us his insights. And please join with me in welcoming him to the stage and hearing what he has to say.
Well, thank you, Michael, for that very kind introduction. He has to talk me up a bit. He appointed me, and it looks bad if he appointed the dud. The invitation to present at this conference asked I address the topic of federalism in the High Court over the past 20 years or so. Now, in the first century of the life of the Constitution, such a paper would have considered the outcome of a series of gladiatorial tournaments between the Commonwealth and the states over their respective legislative powers. A betting man would not have wanted to have backed the states in those contests too often. The states regularly lost, and like it or not, a considerable body of precedent built up, establishing the Commonwealth's broad legislative power to engage in and regulate most aspects of economic life in Australia. The establishment of the Commonwealth's broad legislative powers by that body of precedent in a range of areas resulted in fewer of those state and Commonwealth gladiatorial contests since the turn of the century. The only significant spectacle was the work choices case. There, various states challenged the Commonwealth's use of the corporation's power and other legislative powers to enact general provisions for industrial relations. In that case, if I can maintain the analogy with Roman entertainment, the states played with some aplomb the role of the Christians to that of the Commonwealth's lions. As a result, I don't want to focus too much on the High Court's approach this century to the balance of Commonwealth and state legislative powers in the Federation. An area of greater activity and more interesting developments over the past 20 years has been the High Court's approach to the executive power of the Commonwealth. And here, the Commonwealth has not had things all its own way. The approach of the Court has identified significant limitations in the Commonwealth's executive power, which indicate a continuing role for the states in relation to Commonwealth spending. And over the same period, the High Court has raised, but not fully answered, questions about the capacity for Commonwealth and state governments to jointly administer national legislation which is enacted by more than one polity. And can I turn to consider the approach to cooperative federalism? While the Commonwealth's legislative power to regulate economic activity is broad, it's not complete by any means. There remain limits in the Commonwealth's legislative powers, which mean that the Commonwealth cannot always enact comprehensive national legislation which Parliament might consider to be desirable. Gaps, such as the regulation of industrial relations of certain individuals and partnerships, which the Commonwealth Industrial Relations Law do not catch, may remain. And for the Commonwealth to achieve its ultimate objective, cooperation of the states may be required in order to develop a comprehensive national law which is seen, in the view of the Parliament, as serving the country's best interests. Now, one way in which gaps in Commonwealth legislative powers may be plugged is for the state to refer legislative power to the Commonwealth. Now, that's not a particularly federal solution, and it's one which state parliaments are often understandably reluctant to undertake. Referring power deals state parliaments out of the game and at least substantially deprives the states of the capacity to influence the development of legislative policy which may have a significant effect on the state's residents. Another way of making a national law is for each of the nation's parliaments to pass legislation in the same terms. In practice, however, this proves logistically difficult to achieve for legislation which is regularly amended. And even if it's feasible for each parliament to keep up with amendments so as to maintain uniformity, the question arises as to who is to administer the law. Consistency in administration of the law may be as important as consistency in the terms of the legislation. An alternative approach, which may be practically preferable in those cases where national uniform legislation is considered desirable, is for the Commonwealth to pass a law which is adopted by other polities but administered by a national regulator. And at the turn of last century, the High Court was called on to consider such a legislative scheme involving corporate regulation, that is, the constitution, management and external administration of corporations. This was an area seen by all Australian parliaments as an area preeminently calling for a uniform national approach. The principal gap in the Commonwealth's legislative power concerned its capacity to make laws for the incorporation of companies, which the High Court had held stood outside the ambit of the corporation's power. In addition, the corporation's power relevantly allowed the Commonwealth to make laws with respect to trading or financial corporations. The view had been expressed that the question of whether a domestic corporation was to be characterised as a trading or financial corporation was to be determined by reference to its actual or intended activities. And on that view, there would be some companies which would not be trading or financial corporations, or which would move in and out of that status. And that would give rise to uncertainty as to whether the Commonwealth provisions directed to trading and financial corporations would apply to certain companies. After the High Court held invalid provisions of the 1989 Corporations Act of the Commonwealth, which provided for the incorporation of companies, Australian governments agreed on a national approach to corporate regulation. This involved the enactment by various parliaments of the Corporations Law as a national law. The text of the Corporations Law was enacted by the Commonwealth Parliament as a law for the Australian Capital Territory, relying on the Territory's power. The parliaments of the states and the Northern Territory adopted that law as enacted from time to time as their own law. That is, outside the territories, the Corporations Law operated as a state law. The Corporations Law made comprehensive provision for the incorporation, internal administration and external administration of domestic corporations. Although the Corporations Law operated as a state law throughout most of Australia, it was administered by a Commonwealth statutory authority. A Commonwealth Act established the Australian Securities and Investments Commission as the national regulator. The Director of Public Prosecutions, the holder of a Commonwealth statutory office, prosecuted serious indictable offences against the Corporations Law. Federal and non-federal jurisdiction in relation to civil matters arising out of the Corporations Law was invested in state Supreme Courts and the Federal Court of Australia. The elements of the national legislative scheme which I've just described proved to be its undoing. In re Wackham ex parte McNally, the High Court held that the structure of Chapter 3 of the Constitution was inconsistent with state parliaments having the capacity to invest a federal court with state jurisdiction. In the Queen and Hughes, the High Court raised the prospect of a similar structural limitation in relation to investing Commonwealth statutory authorities and officers with state executive power. And it's a decision in Hughes on which I turn to focus. Mr. Hughes and his alleged co-offender, Mr. Bell, were indicted in the District Court of Western Australia on 3 counts of making available prescribed interests contrary to the Corporations Law of Western Australia. Under the relevant provisions, only a public company could issue investment products classified as prescribed interests. The charges against Mr. Bell and Mr. Hughes as individuals concerned their raising $300,000 from investors in Western Australia for an investment scheme in the United States. The indictment against Mr. Bell and Mr. Hughes was filed on behalf of the Commonwealth DPP. The Commonwealth DPP is empowered under her own legislation to prosecute for indictable offences against laws of the Commonwealth. Now, of course, the Corporations Law, as it applied in Western Australia, was a state law, so the offences which it created were state offences. The Western Australian Act, which adopted the Corporations Law, also contained provisions which had the effect of conferring on the Commonwealth DPP power to prosecute offences under the Corporations Law as if they were Commonwealth offences. The Commonwealth Corporations Act provided that the Commonwealth DPP had the functions and powers expressed to be conferred by the WA law. Mr. Hughes applied to quash the indictment on the ground that the Commonwealth DPP had no authority to prosecute the state offences with which he was charged. That application was removed to the High Court and a number of questions were stated for the full court. The joint judgment was delivered by Chief Justice Gleeson, the Justices Gaudron, McHugh, Gummow, Hayne and Callanan. Now, at the risk of contradiction by one of the authors later today, in my view, what the joint judgment actually decided may be shortly stated. That is, the state provisions conferred prosecutorial power on the Commonwealth DPP as a matter of state law. The Corporations Act of the Commonwealth imposed a duty on the DPP to perform that function and, to the extent necessary, could be read down as limiting the duty to prosecute to state offences which the Commonwealth Parliament could have enacted. The offences with which Hughes was charged related to trade and commerce with other countries within the Commonwealth's legislative competence under the Trade and Commerce Power. They also related to matters territorially outside Australia, but touching and concerning Australia within the Commonwealth's legislative competence under the External Affairs Power. The Commonwealth's Corporations Act was supported by these heads of Commonwealth legislative power so far as it authorised the Commonwealth DPP to prosecute the offences charged in the indictment. So at the end of the day, the Commonwealth DPP was able to prosecute Mr. Hughes. So what, you may ask, was the problem? Well, the problem for the corporations law arose from a number of questions which the joint judgment posed but did not always answer. Possible answers which were suggested by the discussion in the joint judgment could have imperilled the effective operation of the corporations law cooperative legislative scheme. The joint judgment generally accepted that the Commonwealth Parliament may, in the exercise of its incidental power, permit officers of the Commonwealth holding appointments by or under statute to perform additional functions and accept additional appointments. However, that general acceptance was expressed to be subject to, and I quote, what may be the operation of negative implications arising from the Constitution. The Court referred to Chapter 3 of the Constitution, concerned with the exercise of the judicial power of the Commonwealth. But it was not said that this exhausts the relevant negative implications which may arise from the Constitution. The joint judgment then referred to two propositions which the relevant section of the Commonwealth's Corporations Act was said to illustrate. The first is that a state, by its laws, cannot unilaterally invest functions under that law in officers of the Commonwealth. The second is that a state law which purported to grant a wider power or authority than allowed by Commonwealth law would to that extent be inconsistent with the Commonwealth law and invalid under Section 109 of the Constitution. The third proposition, which the joint judgment went on to accept, was that a federal law which imposes duties to perform functions or exercise powers created and conferred by state law must be supported by an appropriate head of Commonwealth legislative power. However, the joint judgment did not, and I quote, stay to consider whether the further step taken here of imposing duties by the Commonwealth law was necessary not merely to implement the agreement between respective executive governments, but as a constitutional imperative. The joint judgment also identified as an issue which it was unnecessary to decide whether the legislative power with respect to matters incidental to the execution of the executive power of the Commonwealth could support a law imposing prosecutorial duties on the Commonwealth DPP. The relevant aspect of the executive power was the entry into the Alice Springs Agreement with the states and Northern Territory establishing the Corporations Law Cooperative Legislative Scheme. Now, the prospect of the issues identified but not conclusively resolved in Hughes being determined against the validity of the legislation in some cases proved too troubling for Australian governments. The result was a withdrawal of the Corporations Law cooperative arrangements and the substitution of the Corporations Law with the Corporations Act of 2001. That Corporations Act is a Commonwealth Act applying of its own force across the nation, with any gaps in Commonwealth legislative power being covered by a reference of power by the states under Section 5137 of the Constitution. The joint judgment in Hughes also made a point about Commonwealth spending. Their Honours said that it was the operation of the Commonwealth law which enabled the Commonwealth DPP to expend Commonwealth resources in the exercise of powers and functions conferred by state law. Subsequently, it has been issues concerning the executive power, and particularly the expenditure of money by the Commonwealth, which have given rise to the most vexing constitutional questions for the Commonwealth concerning the balance of power in the Federation. I turn to consider three cases which have considered those issues. Now, constitutional issues can arise for the High Court's determination in a number of ways. They can arise from a contest between different governments in the Federation, as in the work choices case. They can be raised by individuals fighting for their liberty, as in Hughes. But they can also arise when an unusually determined individual just gets a bee in his or her bonnet. And the tribulations of the Commonwealth in the spending area are largely attributable to two such determined individuals. The first was Brian Pape, who was a law lecturer. More specifically, he was the least popular lecturer in Australia among students in 2009. This was because he challenged Commonwealth legislation providing for a tax bonus of between $250 and $900 to persons with an annual taxable income of less than $100,000. The bonus was to be paid as a fiscal stimulus in response to the global financial crisis. And of course, most students would have incomes that would entitle them to the $900 payment and be in a financial situation which would make them appreciate the money more than most. In Pape and the Federal Commissioner of Taxation, a majority of the High Court rejected the challenge, no doubt to the relief of the student population and others who had already spent their anticipated then windfall. But the way in which the court decided the case exposed limits in the executive power of the Commonwealth to spend money and Parliament's legislative power to authorise its expenditure. The Commonwealth in Pape had principally relied on the provision in Section 81 and Section 83 of the Constitution for a consolidated revenue fund from which money could be drawn under the authority of an appropriation law. The tax bonuses in Pape were held to be the subject of a standing appropriation of monies, which the Commissioner of Taxation was required by relevant legislation to pay to another. So there was an appropriation. Was it enough that the required funds were appropriated by Parliament? The answer by all members of the court was no, that Section 81 and Section 83 did not confer a substantive spending power. The requirement that funds be appropriated from the Consolidated Revenue Fund ensures parliamentary control over the expenditure of public money. However, once money has been appropriated, the power of the executive government to spend the money has to be found in the Constitution itself or statutes made under it. The legislation in Pape was held by a majority of the court to be valid on the basis that the expenditure fell within the executive power of the Commonwealth and the impugned laws providing for the payments were authorised by Section 51, subsection 39 of the Constitution as being incidental to the exercise of that power. The executive authority to spend the appropriated money was found to exist as an aspect of the nationhood power inherent in Section 61 of the Constitution. Under the formulation accepted by Justices Gummow, Crennan and Bell, Section 61 confers on the executive government power to engage in enterprises and activities peculiarly adapted to the government of the nation and which cannot otherwise be carried on for the benefit of the nation. The joint judgment then repeated a point which had been made in Hughes. While Section 51, subsection 39 authorises the Parliament to legislate in aid of the executive power, that does not mean that it may do so in aid of any subject which the executive government regards as of national interest and concern. However, the tax bonus legislation was seen to be valid on the basis that the global financial crisis represented a national emergency which only the Commonwealth had the financial resources to meet. So the tax bonus legislation was upheld on a rather narrow basis in the context where the court identified important limitations on the Commonwealth's spending power. Now, this decision set the scene for the entry of a second determined individual. Ronald Williams was the father of 4 children who attended the Darling Heights State School in Queensland. At that school was a chaplain whose services were provided pursuant to an agreement between the Commonwealth and the Scripture Union of Queensland as part of the Commonwealth's funding of school chaplaincy services. Mr. Williams resented this religious intrusion into the academic lives of his children enough to bring proceedings in the High Court seeking to restrain the Commonwealth from funding the chaplaincy service. In Williams and the Commonwealth, a majority of the court rejected the proposition that, subject to appropriation, the executive power of the Commonwealth extended to the expenditure of public money and entry into contracts on any subject within Commonwealth legislative power. The court also rejected the proposition that the Commonwealth's power to contract was to be equated with that of a natural person. The court held that entry into the agreement with the Scripture Union of Queensland and expenditure of public money on school chaplaincy services was not within the executive power of the Commonwealth in the absence of authorising legislation. The immediate sequel to this litigation was the enactment by the Commonwealth Parliament of legislation purporting to authorise the executive to undertake programs specified by regulation. And as you might anticipate, the school chaplaincy program made the cut in the regulations. However, Mr. Williams was not so easily defeated. He instituted fresh proceedings in the High Court challenging the validity of the new legislation. And in Williams and the Commonwealth No. 2, the legislation was held to be invalid in its application to the chaplaincy services agreement with the Scripture Union and payments made under that agreement. This was on the basis that the legislation only authorised agreements and expenditure which was within the legislative power of the Commonwealth Parliament to authorise, and authorising entry into the agreement with the Scripture Union was held to be outside any relevant head of Commonwealth legislative power. In identifying these limits on the Commonwealth's executive power to contract and spend, the Court has been influenced by the federal nature of the Constitution. In rejecting the Commonwealth's arguments about the limits of executive power in Williams No. 2, the plurality said that the Commonwealth cannot be assumed to have an executive power to spend and contract, which is the same as the power of the British executive. Their Honours emphasised that the Constitution affects distribution of powers and functions between the Commonwealth and the states, and the polity which must, to quote, possess all the powers that it needs in order to function as a polity, is the central polity of a federation in which independent governments exist in one area and exercise powers in different fields of action carefully defined by law. Earlier, in Pape, the majority joint judgment had noted that it's only by some constraint, having its source in the position of the executive governments of the states, that the government of the Commonwealth is denied the power, after appropriation by the Parliament, of expenditure of monies raised by taxation imposed by the Parliament. These cases illustrate that the federal nature of the Australian Constitution carries with it inherent limitations in the Commonwealth's power to spend and contract. The limits in the Commonwealth's legislative and executive powers give rise to a need for cooperation between governments to achieve national objectives where uniform law is considered desirable. Frequently, the Commonwealth cannot act alone and requires the cooperation of the states to comprehensively achieve a desired outcome. The breadth of the Commonwealth's legislative powers mean that it can regulate much economic activity and provide or fund many services. However, the limits in those powers leave room for exceptions which can effectively imperil the administration of the Commonwealth law, if only by reason of the need to consider whether individual cases fall within or outside the relevant constitutional limitation. So far as spending and contracting is concerned, the Constitution provides a ready solution. Section 96 of the Constitution empowers the Commonwealth to provide financial assistance to the states on such terms and conditions as the Parliament thinks fit. The Commonwealth clearly has a broad power to give money to the states and either impose conditions or reach agreement with the states about how the money is to be spent. State governments have traditionally found it difficult to say no to offers of money from the Commonwealth, but the states cannot be forced to accept money for programs of which the state government does not approve. And states will also have the opportunity to influence the policy to be adopted when the Commonwealth seeks to reach agreements with the states as to how the money will be spent. For national regulation, as opposed to service provision, the challenges following the decision in Hughes are greater. It would be unfortunate if the corporations law model were not available under the Constitution. A national legislative scheme administered by a national regulator without requiring state parliaments to abdicate legislative power can have significant advantages. While Hughes raises questions about the availability of such an approach, it does not necessarily answer the questions in a manner incompatible with such a scheme. One thing which is not clearly explained in Hughes is the reason why, in the absence of inconsistent Commonwealth legislation, state parliaments cannot unilaterally impose administrative duties on Commonwealth officers and agencies. Hughes seems to contemplate that administrative powers, which are not coupled with duties to exercise the power, can be imposed with Commonwealth acquiescence. Why can powers be conferred but no duties imposed? It may be that the answer to this question lies in the requirement for legislative authority for Commonwealth expenditure, falling outside certain categories. Commonwealth officers will ordinarily exercise state functions by expending Commonwealth resources. The authorisation of that expenditure may be a matter for the Commonwealth Parliament. A requirement for Commonwealth legislative authority may be thought inconsistent with state parliaments having the capacity to impose a duty on a Commonwealth agency or officer to incur that expenditure in the absence of an authorising Commonwealth law. It may be, therefore, that the key to understanding Hughes lies in the Court's observation that it was the operation of the Commonwealth law which enabled the Commonwealth DPP to expend Commonwealth resources in the exercise of functions and powers conferred by state law. And if that is correct, then the distinction between duties and powers may be of little practical significance. A state law which merely conferred a power but did not impose a duty to exercise the power may be valid. However, legislative authority from the Commonwealth Parliament to incur the expenditure of Commonwealth resources may still be required for the non-compulsory exercise of that power. Even if Hughes is understood in this way, there remains a question not answered in Hughes as to the extent to which the incidental power allows the Commonwealth Parliament to authorise expenditure in the implementation of an intergovernmental agreement establishing a national regulatory scheme. In my view, there's much to be said for the incidental power extending to authorise the exercise of powers and duties under a cooperative scheme. Particularly where the Commonwealth and the states are acting cooperatively and in agreement, the federal considerations which inform the limits on Commonwealth executive power have much less force. One thing which is clear is that the last word has not been written on the limits of the Commonwealth's executive power. The area is likely to remain one in which the High Court remains active for some time, although perhaps it will be particularly active over the next month. And it brings with it new challenges for the implementation of national legislative schemes. So thank you. And I don't know whether we want to take questions now or later.